Okay, good afternoon, everybody. My name is Bob McDonald with Preferred CFO. Welcome to the March edition of our webinar series. Each month, we look at topics in corporate finance and human resources. This week, our webinar is the pros and cons of using a PEO, that's a professional employer organization. Our speaker is Mr. Tom Applegarth. He is a 30-year veteran of human resources. Tom has experience serving high-profile companies such as Amoco, Payless Shoe Source, and Goodyear Tire and Rubber Company. He's also been the HR for many business units, two of which had over $1 billion in revenue and over 3,000 employees. He was also the preferred CFO as the VP of Human Resources. Preferred CFO provides HR, finance, accounting, and payroll services for small to medium-sized companies. If you have a question, please either use the chat function or the Q&A function, and we will address them as they come along. Tom, welcome.
Well, thank you, Bob. I appreciate it. So, professional employer organizations, PEOs, they are co-employment organizations that provide HR services for small and medium-sized businesses. And usually they're providing payroll, employee benefits, workers' compensation, employment law and regulatory compliance help, tax withholding, reporting and payment, and then depending on the vendor, there's other services as well. So there's a lot of small companies that use PEOs. There's definitely pros and cons to it. You know, managing HR and all the tasks that go along with it can be difficult for small and mid-sized companies. A lot of the small business owners that I speak with, they often try and wear lots of hats, and that's kind of a normal human reaction. But I always tell them, if you don't think you're an expert in an area, you're probably right. And HR is one of those areas that I think some business owners try and do, even though they're not an expert in it. And I think that's generally a mistake. And so I think PEOs are one option that people can look at to really help them make certain that they are managing their HR correctly. There's other options. You can hire a fractional HR firm like Preferred CFO, or you can do it in-house. And there's certainly pros and cons to each approach. Cost is often a consideration. And each situation is different, but often the cost is similar between PEOs and a fractional HR firm. But if a company is small, generally, if you're less than 100 employees, a PEO or a fractional HR firm is generally going to be cheaper than hiring an HR manager, and especially than hiring an HR manager that really knows what they're doing. You know, most PEOs offer basic HR services like payroll, benefits, workers' comp, tax reporting, that kind of thing. PEOs generally, there's certainly some exceptions to this, but most PEOs aren't providing a lot of hands-on help around recruiting, management training and development, market pricing of jobs, one-on-one management coaching, employee engagement surveys, succession planning, and other HR needs that may be unique to your business. So most PEOs are offering a cookie cutter approach and often great systems to help in that approach, but aren't really equipped to tailor their needs and become and have one of their employees become part of the management team. And that's really, I think, where a fractional HR organization can really provide a different level of service than maybe what you get with most PEOs. There's certainly, I'm sure, some exceptions. PEOs generally are having their HR managers support 20 to 30 different companies, and therefore that's really the scope difference where they're not able to even have the time to become part of the management team, to attend staff meetings, and to really provide tailored services to a company. But because at Preferred CFO and many fractional HR firms, the HR manager or payroll manager may be working with 3 or 4 different companies, nowhere along the lines of, 20 or 30 different companies. And so it can be a different experience from that perspective. Um, again, PEOs often help with compliance and regulatory and helping with employee coaching and counseling and terminations, but most of them won't go as far as really sitting in on the conversations with the manager and providing that level of hands-on support. And that's where either a fractional HR firm, or if you hired your own HR manager, that's one of the differences between a PEO and either having your own HR manager or a fractional HR manager. Where PEOs can add a lot of value is sometimes they can provide cheaper benefits. Some of the PEOs are self-insured, and so they will bring on a small business onto their self-insured pool and can often provide some cheaper benefits that way. They're pretty selective about who they bring into that pool. So there's a number of times that companies want to go into a PEO pool, and as they have their actuaries and underwriters look at the pool, they'll say, yeah, I'm sorry, we can't have you in our pool. But if you do have a healthy employee population, that's one of the biggest reasons to go in to a PEO, is because they can often provide cheaper health insurance benefits in particular. The other benefits, usually there's not a big cost savings, but sometimes they can provide really significant cost savings from a health insurance perspective. And so I think that's probably the biggest reason to take a serious look at a PEO. And then they often have great computer systems and other systems as well. However, you can get those same systems often from the same provider. Um, a lot of the providers, ADP, Paychex, they have a PEO option, and they have where you can use the same systems, but just kind of buy them a la carte. And that's what, if you hired an HR manager or you hired a fractional HR firm, they're going to usually leverage those types of computer systems from ADP or Paychex or Insperity or other vendors that also offer both a PEO option as well as kind of more of just you pay us a much lower fee and have access to our systems. So where at times the PEO's benefits can be cheaper. However, the business is giving up some flexibility, mostly when you're on the medical benefits of the PEO, especially if they're in a self-insured option. You don't have all the flexibility and options on your benefits that you would if you were purchasing them more a la carte on your own. So that might be one other disadvantage. They might be cheaper, but you don't have all the flexibility that you would if you weren't in a PEO. But there's often times that as companies are looking at their benefits, it's just a choice, and a lot of times cost is more important than flexibility. In which case, sometimes the PEO can provide much lower cost from a medical benefit perspective. Again, most PEOs offer payroll and other services outside of their PEO offering. And so that's where companies can use a fractional HR team or in-house HR manager, but then still leverage the technology that's provided by those PEOs, but not be part of the PEO. And that can often be a more cost-effective solution, and certainly can provide much more flexibility in the services that you receive than if you just go and sign up with a PEO. But no matter what option you choose, I think it's always important that you have HR professionals helping you. Not complying with HR laws can be very costly. And I'll go through some other examples, but my favorite personal example is a company that I was dealing with years ago, and they had a plant HR a plant manager who they wanted to terminate. And so, I was like, well, we probably need to give that, the plant manager had been around for like 30 years, and had really long service with the company. And definitely, if you're terminating somebody that's been with you for less than a year, it's a whole different calculus than if you're terminating somebody with 30 years of experience with your company, and has been with you for 30 years. And so as they wanted to terminate him, I was like, well, I suggest that before we just terminate him, that we really sit down with him, give him a written warning on what the metrics are that he's not hitting as a plant that he needs to hit. Otherwise, we may need to terminate him. They didn't really want to do that, but we went ahead and did it. And we, gave him a really in-depth discussion and a written warning, and really spelled out what what he needed to do, what his plant needed to do, what he needed to lead his plant to do. Otherwise, we were going to have to look at terminating him. After a couple of months, performance hadn't improved, and they're like, all right, now we want to terminate him. I said, well, we could, but we probably ought to give him another kind of final written warning. I mean, he's been with us 30 years. It's not like he's been here 30 months. He's been here 30 years. So let's go ahead and give him another final written warning. And so we did that. And then after another couple of months, it really hadn't improved at all. And so we terminated him. And when we terminated him, I said, well, I think we ought to give him some severance, and have him sign a waiver that he won't sue us, and then we can terminate him. And they didn't want to do it. I'm like, you don't have to give him a lot of money. Let's give him 2 weeks' pay. I mean, it's a very nominal amount of money in the grand scheme of things. Nope, nope. You made us give him written warnings, and we're not going to do it. And I'm like, I think that's a big mistake. But, I mean, you guys are running the company. So if that's what you want to do, go ahead and do it. And so we terminated him. He found a lawyer who was willing to do it, take it on contingency. And so it wasn't costing the employee a dime, the ex-employee a dime. We had to hire lawyers and paying them, a ton of money. And we ended up actually losing. And there's no doubt in my mind, he was alleging that we terminated discriminating on age. And there's no doubt in my mind that we were not discriminating against him based on age. We were discriminating based on performance, which is totally legal. But it doesn't really matter what is true. What matters is what a lawyer can convince 9 out of 12 jurors is true. And that he ended up winning an award of over $1 million. And it's just so happened many years ago. And I tell that story a lot because, there's obviously a lot of subjectivity on when you terminate somebody, and you can never make it totally bulletproof. But in my 30 years of experience, either me or somebody who's worked for me has terminated well over 1,000 people. And we have not had any of them get a lawyer to represent them if they signed a waiver that was properly drafted. There's actually a lot of laws around what needs to be included in a waiver that will be upheld by the courts. But if they sign a waiver that will be upheld by the courts, a lawyer won't touch it. And I've never seen one touch it. And so we could have saved $1 million by giving the guy 2 weeks' pay, because most of the time there's a small chance that he wouldn't have signed it and not taken the severance. And maybe he would have negotiated, and maybe we would have needed to give him 3 weeks or 4 weeks pay. But to me, that's really cheap insurance. And so if you're terminating people and you're not giving them severance, I would encourage you to rethink that decision and talk to an HR person or an attorney or somebody to help you through that to make sure that you're doing it so it really is the insurance that you're paying for. But it's those types of things that can end up costing you a lot of money if you're not doing it correctly. So New York, Southwest Airlines, I mean, it happens with big companies as well, but they are currently facing $100 million lawsuit because they were paying their workers bi-monthly rather than weekly. And, you know, a lot of employers that do business in New York know that, but a lot of companies that may just expand into New York have no idea that that's a law. And I don't know what Southwest Airlines excuse was, because you would think they would have, a lot of HR people and maybe even labor attorneys on staff to help them avoid this kind of an issue. But something as innocuous as paying manual workers, on the same schedule that you're paying white collar workers, in most states, that's not a big deal. But in New York, it's a big deal and can end up costing you a lot of money, and unfortunately, every state in the country has a lot of different laws and are passing new laws every single year. And so you need somebody on your staff who's keeping up with that and making sure that you're not making these types of mistakes. California is absolutely the worst. And in fact, several companies I've worked with that, hire remote employees all over the country have specifically said, we'll hire in 49 of the 50 states, but not California. And I personally think if you have the flexibility not to hire in California, that's probably a good idea because they have, and in fact, in California has more lawsuits from an HR perspective every year than the other 49 states combined. And so staying out of California is definitely a good idea if you can. There's certainly businesses that no, we're in California and we have to be in California, and then you just suffer through. But Hyatt was forced to pay California employees over $2 million in a class action lawsuit that alleged many violations, including not allowing a 10-minute break every 4 hours, and those are the types of things that happen in California, but other states as well, and the type of what, might be um, uh, kind of, rules and regulations that you wouldn't think are that important, but, they can be important. And especially if a lawyer, one of your employees comes and complains to them and tells them about something like this, and then they're like, well, if it's happening with you, it's probably happening with all the other employees. And then they certify a class action, and depending on how many employees you have and what the damages and punitive damages can be, it can add up to a lot of money very quickly. The federal government, the EEOC, recently sued a company for $100,000 in one. The company had an employee who missed many days of work after having a stillbirth. The company told the employee to come back to work, and when the employee didn't come back to work, they fired her. And that was deemed illegal under the Pregnancy Workers Fairness Act passed in 2022. And so, again, it's not always intuitive to everybody, which is why, whether it's a PEO or some other HR professional, whether it be a fractional HR manager or a HR manager that knows what they're doing. And I've worked with several companies who just gave the mantle of HR manager plus whatever else they were doing to several different people. And they didn't necessarily know what they were doing. And so they ended up having some problems. We had one client who had a person who was doing payroll through Paychex, and Paychex is very good software, and they're a fine company to work with. But as they were doing payroll, Paychex is not really all that hands-on, and so you still need to know how to use the software and know what you're looking for and run different reports and check different things. And Paychex had a report that if they had run it, it would have told them, and they were a virtual company and had people in like 15 states or so. Well, there was about six of those states that they didn't pay payroll taxes in for a year. And if they had run the right report in Paychex, it would have told them that, but they didn't know and they weren't really checking. And so, that ended up costing them a lot more money than it would have if they had had somebody who knew what they were doing running their payroll. In 2024, a hospital in Washington State paid $3.3 million in a class action lawsuit. The hospital was paying employees for working through their lunch break and other breaks, but Washington law requires employers to not only pay for the time that an employee works during their break, but also requires employers to pay a penalty equal to the time of the lunch or break for forcing the employee to miss that lunch or break. And so that's not in very many states. And so, if you had a lot of experience in other states but didn't really, kind of expand it into Washington, or didn't, for whatever reason, have somebody kind of looking at this kind of stuff, it's, in a lot of states, you can have people work through their lunch and break, and obviously you need to pay them for that, but there isn't a penalty for that. Well, there is in Washington State. Red Robin agreed to pay $600,000 to four former employees. Four women complained to a manager about a line cook who made offensive sexual comments, and the manager, I think, actually spoke with the line cook, but it continued to happen, and they didn't take further discipline, and that is the kind of stuff that can definitely come back to haunt you. And I think that one thing that I really encourage companies to do every year is to educate their managers on sexual harassment and other types of HR laws that they need to be aware of, because it's not always just the HR manager doesn't always have their pulse on everything that's going on, and managers need to know at least when to call HR and get some help. And this manager obviously didn't take these complaints seriously enough, and it ended up costing Red Robin $600,000. Pearl reached a $2 million settlement with for underpaying 32 workers. They violated state labor laws governing record keeping and payroll timekeeping. And so, certainly there is a distinction, and understanding what qualifies as exempt from overtime and non-exempt from overtime is certainly one of those things. I see a lot of companies who misclassify employees as being exempt from overtime, and so they don't really keep track of their time, and they pay them a salary, and then where I've seen this several times is then an employee gets terminated and they go to the Department of Labor, or they go to an attorney, and the next thing you know, they're challenging whether or not that person was exempt, or could have been paid a salary, or conversely, nope, they should have been paid hourly. And oh, by the way, the employee is now claiming that they worked 60 hours a week on average. And now in many locations, it is, and especially in California, this is the biggest issue, because California has specific states over and above what the federal government has, in defining who needs to be paid overtime and actually shifting the burden of proof on how many hours somebody who should have been paid overtime. It's not, the employee doesn't have to prove that they worked it. They just have to state whatever their estimate is. And the employer in the state of California has the burden of proof of proving that the employee didn't work that amount. And you can imagine how hard that is with somebody that you were just paying salaried and not really paying attention to how many hours they were working a week because you didn't think it mattered. And so it's important to really have somebody who knows what they're doing helping you decide when an employee can be salaried versus when they have to be paid hourly and paid time and a half for everything that's worked over 40 hours in a week. Commercial cleaning company settled a lawsuit for $3 million. The lawsuit accused them of misclassifying employees as 1099 independent contractors. And this is probably the most common mistake I see with small companies. It's really easy to bring somebody on and say, well, I don't want to really bring them on as a full-time employee. I don't want to pay them benefits. I don't want to have to pay my part of FICA for them. And that's really the reason why the government, in particular, the IRS and the Department of Labor, really look at this. And all it takes is one employee to make a phone call to either the IRS or the Department of Labor or an attorney, and that can end up costing you a lot of money. And there's really rigid rules on what would qualify as an independent contractor, and there's a lot of companies that are identifying people as 1099 independent contractors that it's just not legal for them to do so. So this is certainly another area where I think small companies need to get help. A bus operator in Pennsylvania was fired for absenteeism. He was absent due to migraines, and the jury found that he was fired in violation of the Family Medical Leave Act law. There's a lot of rules around what qualifies under the Family Medical Leave Act, and companies need to make sure they know what qualifies and what doesn't, especially before they terminate somebody for absenteeism. And it doesn't, employees don't have to, say, hey, boss, I want to take FMLA leave. If they just tell you about, hey, I've got this medical condition, and so I'm going to have to miss work, that's all they really need to do. And that's all the employee did in this instance, was just say, hey, I've got migraines. I'm not going to be able to come into work. And they were like, well, you've missed too much work. And they fired him, and it ended up costing him some money. So those are just some of the examples, but definitely, I think that my biggest message is all companies should make sure they have an expert in HR helping them navigate all of these types of issues. And the PEO is an option. Fractional HR firm's an option. And then, especially if you have less than 100 employees, hiring an HR manager that really knows what they're doing is an option, but probably more expensive than the other two.
Tom, I have a question for you. I think it's a very common question nowadays with a lot of people that were remote and now they're trying to bring people back to work. What are some of the landmines you want to try to avoid when you're trying to bring your employees back to the office?
Yeah, I think it's a really common discussion. And other than a few of the companies that I work with that are fully remote, most CEOs that I speak with um, if they have an office space, they want to try and bring employees back into the office. And my question to them always is, why? And their answer is often, well, I think we get some teamwork, we get some camaraderie, we're missing some tangible benefit. And I think that's very legitimate thing to think about. But you're going to lose a lot of people if especially if you're going from being totally remote to 5 days in the office. And and so I always encourage the CEOs that are talking about this. And it's different if the CEO is actually also, the manager managing the employees. Well, then they've got a pretty good pulse on the business and know what they're talking about. Some of the bigger companies where I talk to those CEOs where they may have two or three or four levels of management between them and the employees. I'm like, are you really sure this is what you really need to do? And in those circumstances, at least the handful of times that I've talked to those types of CEOs, when you talk to their direct reports, they're like, no, we ought to stay fully remote because we're gonna upset employees, and we're going to not really be more effective. And so I encourage people to always identify for the company, but then it ought to, if the CEO identifies with his team for the company, what are the 4 or 5 metrics that you want to measure that will tell you whether or not your company's being successful? And then each of the CEO's direct reports ought to have the 4 or 5 metrics for their area of the business that help the CEO understand whether or not they're being successful. And then it ought to cascade down. And ultimately, every employee ought to have the 4 or 5 metrics that say whether or not they're being successful. Now, some employees, some jobs are easier to do that than others, but if you can't identify the 4 or 5 metrics that tell you whether or not that job is being successful, I think you really ought to question whether or not you need that job. And I've never seen where if a company does that, that even one of those 4 or 5 most critical metrics is how much time people are spending in the office. And so I really encourage people to think through that. It seems to be a pendulum that is swinging back hard, but I'm not, and there's certainly instances where it's the right thing to do for the business, but there's other instances that I've seen where they force people back in the office and lost a lot of good people and lost employee morale by doing that.
All right. Thank you very much, Tom. If you have a specific question about your company you'd like Tom to answer, just drop us a note in the chat and we'll connect you. Thank you to Tom today, and thank you to Tara behind the scenes. Please join us next month on April 28th for our next webinar entitled, What is Financial Forecasting and Planning? Thank you to everybody for attending today, and we will see you next month.